BBC Radio Scotland.
Good morning. The UK government will set out its plans later for laws after Brexit. Ministers say they want to end the direct jurisdiction of the European Court of Justice in the UK. Critics say the word direct leaves room for the court to still play a part. Alfonso Valero is a lecturer in European law at Nottingham Trent University. He says British companies who trade in Europe will still have to toe the line.
Apple has received a very hefty fine from the European Union, so has the Google. Those are American companies, yet they had to adapt their trade practices to those demands of the EU insofar as they want to operate in the EU area.
Theresa May has insisted that the UK will no longer be subject to the rulings of the European Court of Justice after Brexit. The UK government has issued proposals explaining how it thinks trade disputes should be resolved when Britain leaves the bloc. Legal experts have warned the UK is likely to have to follow the court's rulings if it wants to remain closely linked to the single market. But the Prime Minister said new arrangements would make sure British businesses could continue to trade across the EU.
When we leave the European Union, we will be leaving the jurisdiction of the European Court of Justice. What we will be able to do is to make our own laws. Parliament will make our laws. It is British judges who will interpret those laws, and it will be the British Supreme Court that will be the ultimate arbiter of those laws.
What it calls its guiding principles with regard to the influence of the European Court of Justice after Brexit. It says it will not allow the ECJ to have direct jurisdiction over UK affairs. On a visit to a factory this morning, the Prime Minister spoke to reporters about the plans.
When we leave the European Union, we will be leaving the jurisdiction of the European Court of Justice. What we will be able to do is to make our own laws. Parliament will make our laws. It is British judges who will interpret those laws, and it will be the British Supreme Court that will be the ultimate arbiter of those laws. What we've done today is issued a paper which shows a number of ways in which it will be possible to resolve disputes. I think what businesses want to know is that in future relationship, if a dispute arises, how will it be possible to resolve that? We're very clear. We won't have the jurisdiction of the European Court of Justice. We will put in place arrangements to ensure that businesses have the confidence of knowing they can continue to trade across the European Union.
Well, Professor Steve Pears is an expert in EU law. Hello, Professor.
Good afternoon.
Now, remind us, first of all, what the European Court of Justice is and what powers it has.
Well, it has one judge from each member state, and it has powers to interpret EU law across those member states, obviously the UK and the other countries as well. Our national courts in Scotland, as well as the rest of the UK, can and often do ask questions to clarify what EU law means in a particular case. So it can't rule on things which have nothing to do with EU law, like rates of pensions or rates of income tax and all sorts of things like that. But things like parts of employment law, parts of environmental law, and EU citizens' rights and so on, it does often rule on.
Now, Steve, Theresa May has said that we'll be able to make our own laws. Parliaments will make the laws. It's British judges that will interpret the laws, and it will be British Supreme Court that will be the ultimate arbiter of those laws, and we'll take back control of our laws. So what options does the UK government have in terms of extracting itself from the ECJ?
Well, the paper they've just produced says again and again, sort of no, 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 like Mrs. Thatcher used to say, that you won't have any control by the ECJ of the UK after Brexit. And then it lists a whole series of other types of international dispute settlement that the government would be willing to sign up to. And I think the way in which they've tried to explain it is to make a distinction between what happens within the UK in our courts and what you can do in British courts, and what happens as between states, or as between states like the UK and an international organisation like the EU. And you have a divide. There'll still be disputes where the UK might lose or win fighting the EU in some kind of international tribunal, but it won't have an impact directly on British law. Now, that might still be indirect, because if the government loses, they might feel a need to change the law. But it won't have the kind of direct impact that you have today.
We all go through our daily lives and things affect us. Just explain to everyone listening, how does the ECJ affect everyone listening and their daily lives?
Well, it's, for instance, if your company changes hands and you're working for it, the EU court has clarified the EU law on saying that workers, in principle, start out with the same rights they had under the previous employer. If you have a sex discrimination claim, there's quite a lot of cases on equal pay for women, equal treatment for women that the ECJ has clarified, some of them from Scotland or Northern Ireland or England. And there's a number of others as well about shop opening hours, for instance, and so various ways in which we live our daily lives, not every detail, but certain aspects of it have been clarified by the EU court, and that will, at least in a binding way, would end after Brexit.
So can the UK remove itself from the court's jurisdiction while staying so close to the single market and the customs union?
Well, in theory, it can. I mean, countries like Norway and Iceland and Switzerland have done it, but they've sort of done it by creating other things in place of it, either an EFTA court, which is actually quite similar to the EU court for Norway and Iceland, and sort of informal understandings or commitments in the case of Switzerland that they sort of have to, in principle, go along with EU law if they want to have that close relationship. So those are sort of compromises, and maybe there'll be enough for some of the people who voted leave, but some of them who voted leave would still think that's maybe going too far if we end up in a relationship like that. But we'll see. The government seems open to all sorts of possibilities other than, as long as it's different from what we have now in terms of the ECJ being binding.
Steve, to what extent could some areas of the Brexit process end up actually being decided by the EU courts?
Well, there could be quite a few things that go to the Brexit process. I mean, the EU side isn't very clear if the transitional deal could be included within the scope of Article 50, and if it can't, then it's quite difficult to negotiate all these things on time. We'd have a sort of cliff edge on Brexit Day of ending our relationship with the EU, at least for a while. So that's a very important question that might have to go to the EU court. And if there is a transitional deal possible, what are the outer limits of it? Are there some things it couldn't cover, like tax cooperation or things like that after Brexit? Or does it have to be limited in time? How long? And then post-Brexit deals, probably there'll be legal questions about exactly what the post-Brexit deals between the EU and the UK could cover. And the EU court will end up interpreting them on the EU side, at least. Even if it's totally excluded from doing that on the UK side, it'll be doing it on the EU side as it does for treaties with the US and India and whoever else, non-EU countries.
Thank you very much indeed, Professor Steve Pearce, an expert in EU law.